It's spot on 12:30, so we are going to start this webinar. Welcome to those online. My name is Prue Gordon and I am the Executive Director of the Australian Centre for International Trade and Investment. We're a relatively new organisation. We aim to try and increase the awareness of the importance of international trade and investment for Australia and Australians, and create opportunities to have innovative discussions between government and academics and industry working at the coalface of international trade. So today we are extremely fortunate to have with us the extremely talented Jessica Giovanelli from Moulis Legal. Jessica, and the topic for today is Australia's, or the consistency / potential inconsistency of Australia's fuel standards or proposed fuel standards and other trade environment sort of conundrums. Let me just tell you a little bit about Jessica. I'm sure she'll be very embarrassed, but she has the most incredible CV and is an incredibly talented person. So Jessica, she's special counsel at Moulis Legal. She's an international trade law expert. She has a Bachelor of Law with honours and a Bachelor of Arts in International Relations from the Australian National University. She has a Master of Laws from the London School of Economics and Political Science and a Diplôme du Programme International in International Law and Politics from Sciences Po in Paris, which I assume was done in French, Jessica.
Yes, that was, yeah.
She's worked at Department of Foreign Affairs and Trade, at the Attorney General's Department. She's worked at the World Trade Organization and the United Nations. She's worked in the private sector, and she's even had a bit of a stint in academia as a research assistant. So Jessica is the complete package when it comes to international trade law and a bunch of other things as well. So we're really fortunate to have her here today. Part of the reason why I invited her was because she wrote this fascinating piece on Australia's proposed fuel standards. And obviously the whole relationship between climate change measures and existing international trade law is such an area of interest, because there are so many developments in the global economy where governments are introducing measures to achieve climate change as well as national security outcomes, which don't sit comfortably with existing trade laws. And you look at things like the US use of national security as an exemption for its steel tariffs, for example. It's just sort of the tip of the iceberg. So I thought the fact that Jessica's done this work to look at Australia's fuel standards would be wonderful to look at that work, but also go beyond that. So I'm going to hand over to Jessica. We were actually going to turn this webinar into a meeting, because the people online are quite awesome in their own right. So if I can do that easily, I am going to turn this into... No, I don't think I can. So since I can't turn it into a meeting, which I thought I could, but now I can't, please, I would encourage you all to use the Q&A section as we go through this webinar and ask questions and try and turn this into as much of a conversation as we possibly can. So at this point, please let me hand over to Jessica and take it away.
Thanks so much, Prue. Yes, I'll perhaps start with just a brief introduction of myself, though Prue has pretty much covered it all. I'm a special counsel at Moulis Legal, which is a boutique firm which has a bit of a specialist focus on trade and regulatory matters. And as Prue mentioned, I've worked previously as a WTO dispute settlement lawyer in Geneva, and before moving to private practice, I also worked in government, both in the trade law team at the Office of International Law in the Attorney General's Department, and in the Office of Trade and Investment Law at the Department of Foreign Affairs. And I did do a stint as a treaty negotiator as well for Australia. So I actually have about 16, 17 years of experience in looking at basically whether a measure is consistent with WTO laws and or free trade agreements and or international investment law, and thinking a lot about balancing interests in this field. And it's at that kind of really interesting tension point where a lot of the work that my firm does and that I'm interested in really happens, which is what is fair about all of this stuff, and what are the objectives and priorities that should be given precedence. So that's really interesting. So the background to this webinar is that the new vehicle efficiency standard has been proposed by the Australian government, and it's before Parliament at the moment. And at the same time, around about the same time as that was brought before Parliament, a new WTO panel report came out that dealt with similar questions. And we thought that it highlighted some really interesting tensions. So I wrote that piece about it, and Prue has asked me to present a webinar based on it. And as Prue just mentioned, in several ways, it's just an example of those larger tensions, which we're going to get into today. So I'll just give a quick overview. I thought we'd do a really quick introduction on trade and environment before moving into what the new vehicle efficiency standard proposals are, and then just look at some WTO rules, deal with the kind of most recent WTO panel report. I have read it cover to cover, so you don't have to. I mean, I would definitely encourage everybody to read it, but it is a very technical report. And so if you don't have the time or the inclination, I have read it and I will give you a rundown so you can seem informed at your next dinner party, which I'm sure everybody listening to this webinar has extensive kind of discussions about these sorts of things in social conversations. But yeah, so then we might move on to a final kind of comment on the climate and trade tensions. And hopefully we'll get a discussion going about that, because this will just be a starting point to get onto those really meaty and weighty issues that Prue has mentioned. So to go to a Trade and Environment 101, so essentially the multilateral trade regime is really about distributions of the gains from trade and preserving an equitable playing field and an equitable kind of distribution of those gains by seeking to check discrimination and protectionism, so that there are opportunities for countries to realise their specific advantages. So there's always been concerns that trade rules are serving economic interests at the expense of legitimate policy objectives. And if we cast our minds back, and I have used a pretty historical photo here, we cast our minds back to 25 years ago, to 1999, this really has played out in a rather spectacular way in the Battle for Seattle, which was a big civil society protest against the WTO, which kind of turned into a riot. And it had a really strong environment focus because the WTO had been dealing with really important foundational challenges about how it was going to balance trade and development interests with environmentally focused policy. And interestingly, I did recently find out that they've made a movie about it in the year 2007, which has Charlize Theron and Woody Harrelson, and it has Andre 3000 as an environmentalist in a turtle costume. And I haven't seen it, but it is on my to watch list for the next rainy weekend, because that kind of seems really interesting to me, and a bit kind of I didn't realize that anyone would be so interested in the stuff that you do every day to make a movie out of it. So yeah, I'll be watching that one. So over the course of the past 25 years, they really refined. There's been this kind of steady refinement of how the WTO trade rules are applied to try and get the balance right, and I'm going to give a little bit more detail on that in my later on in my presentation. But there has always been this development element to the global rules of trade. And we'll see that, you know, there is that kind of, that clash of development and environment is not exclusive to trade. It's a part of a much larger question and a much larger set of tensions. And there has evidently been a kind of resolution, a kind of a point where people have started to feel that there is a way to view this through the concept of sustainable development. So the way of meeting our own needs without compromising the ability of future generations to meet theirs. So then moving to trade and climate, the climate change regulation is very much a burgeoning field. And I was in a formal discussion in about 2018 that was focused on trying to do some future casting and some imagining of the next big challenges over the coming decades and how they'd interact with trade and investment law. And somebody said, climate change. And a couple of people said, but that isn't going to be very relevant for trade at all. And I found that to be a really surprising comment. On one level, I understand, you know, the international climate change legal or regulatory regime, that's a self-contained treaty regime. And there is a real reticence for WTO law, which is another self-contained treaty regime, to police or to stray into that territory or try and sort of import norms from those, unless they really, really have to. So in a way, they're kind of two siloed regimes. So people may see that seems that there's no way that they are going to interact. But I very much think that climate change mitigation is going to be hugely relevant for trade, because we are going to see, we're already seeing a lot of regulation, a lot of economic tools being used to try and influence mitigation domestically, to try and influence the actions of other countries, with policy objectives being given as climate environment related that are, as you noted in your introduction, being overlaid with friendshoring, with security issues, with energy security issues, and with kind of a new industrial policy that has climate change as its centrifugal force, you know, that's kind of bringing it all together, or its justification. So the question in the WTO context is, okay, so you're doing climate change or you're doing another environmental issue, but how should that be done in a way that is globally fair? And that's really the point that we come to in this webinar. So climate change mitigation has long been recognised in the WTO as a very legitimate policy issue, but it's just starting now to sort of be then questioning, is the way that you're doing it fair? Even if it seems like a neutral measure, are there ways in which it is somehow not being done to allow those opportunities for everybody? So moving now to Australia's fuel efficiency standards. For a long time, you know, we have had voluntary fuel efficiency standards in Australia, several years. And at the moment, the government is trying to encourage the uptake of fuel efficient vehicles in a more structured way, in a more regularized and regulated way. And the government's emphasized that every developed economy has mandatory fuel efficiency standards except for Australia and Russia on new vehicles. And there's another sort of emphasis that this is not just for electric vehicles. This is a diagram taken from the consultation paper that was put out for the new vehicle efficiency standard. And it is trying to highlight that traditional internal combustion engine vehicles can also, you know, become more efficient in how they use fuel. And so that the principle is not just that it will affect electric, or it's not to try to exclusively prioritize electric vehicles, but it's also to try and get vehicles that are more efficient for technical reasons as well. So the government's also pointed out in its consultation in developing the fuel efficiency standards that the reasons behind the use of a new vehicle efficiency standard are to try and bridge a kind of a supply side behavior issue, which is that the manufacturers want to send their most efficient vehicles to countries that have these standards, and they will send apparently less efficient vehicles to countries where it's not so strict. And one of the reasons given is that they want to recoup the production and development costs of existing internal combustion engine vehicles in those markets to kind of extend the shelf life of the product. So the government's goal has been to pressure manufacturers to direct more efficient vehicles to Australia. And they've actually said that their intention is to require the suppliers, which is generally the importers, to include more modern fuel-saving technology in the new cars sold to Australian consumers to get a greater range or a greater sort of availability of cars. And they've really kind of emphasised that it's about accessibility to different models of cars so that people can choose which ones they want to use. So there's been several rounds of consultation, and the Parliament is considering, Australian Federal Parliament's considering the legislation at the moment. It was introduced just before Easter on the 27th of March. And it's a proposal that would see the legislation come in January 2025, next year. And suppliers in Australia, so that's usually an importer, they'll be given a kind of average yearly carbon limit, which they call a headline limit, for the collective fleet of new vehicles that they supply into the Australian market. And there'll be a system where you can have a credit if you're within your limit, that you can then trade with another supplier. And another complication is that there's going to be two separate categories, one for passenger cars under a certain weight and some SUVs, and then there's another for sort of vans and other light commercial vehicles and some larger four-wheel drives. So there's going to be a penalty if you go over that target limit. Those penalties, it's proposed, will start in July of next year. And there'll be a kind of reduction in what your limit will be. So an increase in effectively what your burden will be. And that's going to be phased in till 2009. And for all of the lawyers out there, this is actually it's an excerpt from the proposed legislation that just shows the limits that are proposed, and that's in grams of carbon per car. So the current average, I think, carbon per car emission is about 180 grams. So that's going to, and that is, I think, for what was at that time in the column 1 vehicle. There may have been some changes to that. So forgive me if the actual carbon per carbon average car output has a slight change now, depending on definitions. So there has been a sense that from the consultation period to the presentation of the legislation in Parliament, the proposals were watered down somewhat. So there have been a few changes. There was a higher there was a reduction in the target. That is, the limits were actually increased for both categories, and the vehicles have been shifted around between the two categories as well. So some four-wheel drives that are often used in Australia as family cars, like your sort of like a Nissan Patrol, will now be in the light commercial vehicle category and subject to a higher limit. And they've also extended the period for transition a little bit as well. So to move to the bit which I consider to be the sort of meaty bit, which is the WTO rules that might apply. The first stage in looking at WTO rules is to try and characterize the measure to see what the rules are that will apply to it. And there are some aspects of the new vehicle efficiency standards that I think a lot of people initially might think, oh, these are kind of in the zone of a rebate or a subsidy for an electric vehicle. So we've had in Australia some state-specific subsidies that are often related to not having to pay income tax, or might even just be a kind of rebate. Those are being phased out as the new vehicle efficiency standards and other measures are being phased in. So the question is kind of what place are they occupying? Are they still seeking to incentivize the uptake of EVs? Are they working as a kind of tax on carbon heavy vehicles? Are they in fact the government directing the suppliers to transfer funds in the form of potentially credits in a way that supports the uptake of electric vehicles? Some of those have equivalents in the characterization of a subsidy. They're also potentially a technical regulation. A technical regulation is a mandatory standard, and there are specific rules that relate to that. And then they can also be, there are some questions about whether the mandatory nature of them makes them a technical regulation. Sometimes an economic penalty is enough to make a standard effectively mandatory. So that would mean that it would be difficult to sell a vehicle that did not have these particular fuel efficiency limits. If it was severe enough, that could rise to the standard of being actually a mandatory implied limit for those vehicles. And then the measures would very likely be classified as a behind the border restriction or internal regulation that affects how products are sold on the Australian market. That seems a fairly clear one. And for those particular ones, you can't have behind the border restrictions or internal regulations that create unnecessary obstacles to trade, and there cannot be more trade restrictive than necessary to fulfill what is called a legitimate objective. So that means that even if they're geared to a legitimate objective, under WTO rules, the measure can't result in arbitrary or unjustifiable discrimination, either against a particular WTO member or between, or preferences between WTO members. So you can't kind of discriminate against all WTO members, and you can't create a situation where you are favouring another WTO member. This is very sort of easily well-trodden ground. But what I think is quite interesting is that around the same time that the measures were introduced into Parliament, which was about 2 weeks ago, the WTO report on EU palm oil was released. So there was a dispute brought about the EU's regulations concerning palm oil, and it deals with these kinds of issues which and it really gives quite a few insights into how that panel thought that climate change mitigation or other environmental action would be considered fair in terms of trade rules. So the EU palm oil dispute focused on an EU regulation that imposed a cap and phase out on palm oil based biofuels, which is a tropical product and it's cultivated primarily outside the EU, whilst biofuels from products from crops such as rapeseeds, soybeans and sunflower, which are cultivated within the EU, were subject to a higher cap and they didn't have a phase out. And Malaysia brought this dispute against the EU and argued that even though the justification given was one of seeking to reduce climate change by arresting the degradation of forestry in place of agriculture and reducing the role that forests play as a carbon sink, Malaysia argued that the way that it was implemented was in effect actually protectionist, even though the EU was adamant that it was a climate change measure. Malaysia said it was a protectionist measure. So this WTO panel was confronted with the really thorny issue, and the WTO panel made a pretty strong statement and ran through quite a few previous panels that had also said that global warming and climate change pose one of the greatest threats to life and health on the planet. So they were very clear that it is a legitimate policy objective to seek to mitigate climate change. But when they delved into it, they looked at the way that the policy had been implemented, and the EU discriminated against palm oil-based fuel from Malaysia by essentially making it difficult for Malaysian exporters to compete with equivalent biofuels, because that was part of the test, was whether the biofuels could all be treated as kind of like goods. And they made it difficult for those biofuels to compete with the EU-derived biofuels and those from other countries coming from rapeseed and sunflower oil and soybeans. So the panel really did say that the climate change justification couldn't be a blanket excuse. It couldn't justify aspects of the program's design that the panel found were unfair. And those aspects were that the EU had chosen data. Specifically, it had had a cutoff date for the data that it chose, so that it didn't take account of deforestation that had happened potentially in the EU before a certain date, and it only focused on deforestation that had happened at a more recent time. They also didn't update the data in a timely manner. So they said they would update the data, but they just kind of didn't. And so it wasn't clear that measures that had been potentially taken were being taken into account in the EU. They had very ambiguous criteria, perhaps deliberately so, as one particular panelist felt. And the time limits for certification procedures meant that a perennial crop for like oil palm was in a way, it was a rather complicated manner in which it was disadvantaged compared to the certification and crop time limits that were imposed by the EU. It's all very technical. It's rather difficult to read and to get into. And I applaud the panel for having actually marshaled all of the evidence in the way that they did. And the panel ultimately did find that there were deficiencies in the way that the program was designed and implemented that resulted in a kind of arbitrary or unjustifiable discrimination. So there was, in addition, a dissent within the panel that felt that there was sufficient scientific and other evidence presented in the dispute to indicate that for them, this was actually a deliberate ploy on the part of the EU. This was deliberate protectionism. It wasn't just accidental, unjustifiable, or arbitrariness that had resulted in discrimination. It was, it had a deliberate protectionist purpose. And that was really related to how, in particular, soybeans were downplayed in some of the WTO, in some of the EU's data in how they went about assessing which ones were the most degrading and which ones had a poor impact on climate change. So it was a really interesting dispute because climate change was the major focus as you know, a really important thing to be seeking to to mitigate and to important legitimate regulatory objective. But it had been gone about in such a way that the development aspects from the WTO's point of view were not being kind of adequately kept in view, and the gains from trade were not being adequately shared around in a very kind of basic format. But that's what ultimately the working through of the law ended up with. So if we look at the new vehicle efficiency standards then with that lens, and the fact that they're sort of talking about directing manufacturers to change the way that they're supplying cars, we find that really electric vehicles and hybrids from countries where those standards already exist, or where they're already being directed to markets where there are stringent standards, will have a much easier time. They'll be much more advantaged when Australia moves to a new vehicle efficiency standard, and they will have a product mix that's adapted to those kinds of standards. They will have fleet options that will allow them to easily capture carbon credits, and they will be much better able to meet certification standards, and they will already almost certainly have certifications that prove the vehicle emissions performance of all of the vehicles in their fleet. But there will be other manufacturing entities and other manufacturing countries that produce and assemble and ship more traditional vehicles, so those with CO2 footprint. And those countries are going to go into fossil fuel debit. And because there is a potential for equivalence issues, which is a way of saying that you're not able to meet the certification requirements and the technical criteria, that if Australia adopts certain certification practices that don't take into account that lag, then there will also be potentially issues with, I guess, the certification and the ability of entities and countries to meet requirements, either in a way that is purely for technical reasons, a little bit like Malaysia's Malaysia's difficulties in meeting certification requirements because of differences in the way that the crops were grown, but also because of the, I suppose, lag in being able to adapt to a product mix that will meet Australia's criteria. So we do know that the countries that might apply to are assessing the impact that Australia's potential new vehicle efficiency standards will have, and will be are really looking at how that will impact on their exports to Australia. And the clearest indication of this was that there was a real message sent by Thailand during the ASEAN summit in Melbourne earlier in March, that they would be looking for a more graduated phase in of the regulations. So that comment was made based on the proposal that was put forward in the consultations, I understand, and the one that has gone before Parliament in late March, several weeks later, did have a more graduated phase in, and it did have a much less strict immediate impact. So there was a softening of the time to be implemented, and a softening also of the limits that were imposed. So Thailand is a major exporter of work trucks. It's a major exporter of the heavier vehicles, and those product categories, which are quite popular in Australia, would be affected. And so it's really interesting that Thailand made those representations, and also interesting that there were changes made to the proposals before they went to Parliament. So essentially, yes, sorry, I should have had this slide up previously, but yeah, the manufacturers will look to issues around certification requirements. They will look to issues around timing. They'll look to whether the implementation will be graduated and will be phased in a way that will allow them to start to meet those criteria in a more kind of equitable way, because those countries that are currently producing vehicles that don't sell as much into markets that have strict measures are also those countries that are developing countries and that would stand to benefit from the gains of trade. And the palm oil dispute effectively sort of shed light on a willingness of panels to examine at a very forensic level whether those gains from trades were being sort of shared around in an egalitarian way globally, in a fair way. So it will be a real issue going forward whether a measure that says that it is a neutral measure that seeks to mitigate climate change or adapt, or to try to put forward a legitimate policy objective, does have the underlying fairness issues actually taken into consideration. So the palm oil report provides us with, I suppose, some insights about how trade and development are really butting up against legitimate policy concerns, which climate change mitigation is a very important one. But it also, for me, highlights that the major tensions playing out aren't exclusively between environment and trade, but there is another tension or problem that's common to both climate efforts and multilateral trade rules, and that is a tension of global equity and intergenerational equity. And in the climate change context itself, there are real questions about common but differentiated responsibilities for climate change mitigation versus who contributed to the problem. And then in the palm oil report, there has to be flexibility in the design and application of these kinds of rebalancing schemes. So especially for those who are going to be affected by climate change and by a shift towards discrimination and protectionism, which are developing countries. And we did see coming out of MC13 that there is a willingness to give a renewed emphasis to the importance of special and differential treatment for developing countries in the WTO. And so from my perspective, you know, it's really interesting that this issue of global equity and how things are distributed and responsibilities are attributed is almost it's almost a theme that is in common to both trade and climate change issues, rather than one that is sort of in conflict per se. It's the same problem, it's just playing out in two different arenas, which is you know, how do we make sure that there is a kind of global fairness to both of these global objectives. So I'll leave it there, and if we want to perhaps start with comments and questions, then yeah, I'm happy to.
Thank you so much. That's amazing. All of you will have seen why I can't turn this into a meeting. I have given all the opportunity to speak. So if you do want to say something, please just turn on your mic, and I'll see that, and then I'll invite you to have a comment. So that was really fascinating. Two things for me came out of it. One, it's like a carbon border measure by another name, essentially because Australia imports all its cars. So effectively, it is a carbon border measure that Australia's implementing, but specifically tailored to cars. And secondly, of course, with any of these issues, the devil is always in the detail in terms of whether it's consistent with WTO law or not. It's really the very fine crafting of how the measure is designed and how it's implemented. And then, of course, the question of whether someone's going to challenge it. So the point you raised about Thailand actually mentioning it at the ASEAN summit, I wasn't aware of that, and that's quite fascinating, considering we had after the Thailand-Australia Free Trade Agreement and how important cars were as a part of that. I think Eleanor Sanderson was turned her mic on. Would you like to ask a question, Eleanor? Okay, maybe this isn't quite working the way we expected, but no problem at all. So you've set out really interestingly the case and the issues around fuel standards. I don't know if you know, at this point in time, the Prime Minister is in Queensland announcing a new, Future Made in Australia Act that the government is going to be introducing into Parliament. I think this is a further step in what the government's already announced, originally around critical minerals, but more recently the $2 billion solar package that they've announced. And so that goes to that issue of government subsidies and government support for industries, primarily aimed at achieving climate change and emissions reduction measures. So you've highlighted how the palm oil case in the WTO, while it highlighted the importance of climate change, didn't fall down really on the side of enabling climate change to be used as a blanket measure to exempt a range of government policies. Government still needed to observe the other rules to ensure that there was this, there wasn't protectionist intent and that it was meeting the other goals of the WTO. So I haven't looked at the solar package in particular, and obviously we haven't seen the Future Made in Australia Act yet. They'll be really fascinating pieces of, well, that'll be a really fascinating piece of legislation to look at. But I guess in your view, and I guess looking at case law in the WTO, have there been any examples where climate change has been able to be used as an exemption, even as an environmental, is it Article 20 or 21, as an environmental exemption that enables countries to implement whatever they like? Or is really the palm oil case the telling case?
There's been a number that have addressed climate change, and there's been it's an Article 20 question, which is, so even if your measures are inconsistent with core aspects of the WTO agreement, there is a provision in GATT, which is an exemptions provision, Article 20, and that several categories underneath in that provision that climate change fits into things about health and environment. But that provision is always governed by an overarching need for that to not be arbitrary or unjustifiably discriminatory. And so there have been instances where there has been found to be no discrimination, no arbitrariness. It's just a straight, legitimate policy objective. And when you look at those cases, there is kind of a forensic level of investigation, but perhaps this dispute goes even further, and it has gone into it. And I think one of the reasons this dispute has been so interesting is because it didn't sort of shy away from it both being a really important regulatory concern, but it also didn't shy away from it not meeting that overarching requirement of non-discrimination. So there have been definitely cases where people were successful in arguing that climate change, that their climate change measure was not discriminatory. But yeah, there's obviously the other question that you raised, which is the more recent use of subsidization in the transition to energy as a form of new industrial policy, with a kind of a sense that the framework of global energy is changing, and that requires an injection of funds, and this is a type of new industrial era where we're changing from one type of industrialization to another type of industrialization. And those are occurring, this is all occurring at a time of, I suppose, very interesting geopolitical and strategic tensions, where those projects like the US Inflation Reduction Act, which Australia and the morning papers this morning said that Albanese was going to be announcing Australia's version of the Inflation Reduction Act today. And I'm impressed that those of us who are here instead of waiting eagerly for that. And having read the Inflation Reduction Act now in some detail, it has elements of it that are of a strategic and friend-shoring nature, which is quite an interesting kind of overlaying of different objectives, as I think we kind of were saying in the beginning as well, which is that we're seeing climate change now and energy transition and the use of new industrial policy and the use of subsidization and the use of regulations all happening at a time when there are larger, also grand strategy issues and goals, and they're being kind of all shunted together, and it's kind of really hard to tease them out and figure out which boxes they fit into. And that is going to be a really big challenge, because people can't just say, oh, this is a climate change measure, without expecting that it's going to come under a lot of scrutiny as to whether it also does fit within the framework of what's considered to be acceptable practice in the multilateral setting, if it ever continues to have relevance, because it will become a really interesting part of the discourse, whether or not people, as I just said, will actually make changes to how they do things based on whether or not a multilateral WTO panel will find in their favor or not, is a completely different question. And that is also part of the very difficult moment that we're in, because we don't know whether people even will take on board the kinds of multilateral rules questions, or whether they will ignore it entirely and just seek to throw their weight around. So yeah,
Yes.
panels may look at it, may find one way or another. Whether or not it actually will make much of a difference is a completely different question.
And of course, China's taken the US, has launched a WTO dispute against the US Inflation Reduction Act. So who knows, they might even take one against Australia's mini Inflation Reduction Act, something to look forward to. But the outcome of that case will be absolutely telling and go to that point that you've just raised as to whether the US will pay any attention to a panel ruling that finds against them in any way and against the IRA in any way. Yes. Denise has put her microphone on, so if you could, Denise, if you would like to ask your question, if you could just introduce yourself briefly before you ask your question, that'd be great. I'm not sure. You should be able to speak, so I'm not quite sure, but we don't seem to be able to hear you. So Nicholas Frank, you have also raised your hand to ask a question. Would you like to try, and we can find out if this is a technical issue, or let's have a go. Nicholas.
Yeah, sure. Can you hear me okay?
Perfect. Thank you.
Okay, great. Yeah, I'm Nick Frank. I'm a laureate research fellow at ANU. And a lot of my work is focused on exactly this question, the intersection between trade and climate change, really how those two regime complexes interact with one another. And I swear that this is not a plant. I'm also Jessica's partner, but this is actually the first time I've heard this presentation. And a lot of this has been focused on the multilateral system, but what we've seen in the last couple of years is that specific climate change provisions have crept into trade agreements. There've always been environmental provisions in trade agreements, but specific climate change provisions with an increasing level of teeth have found their way into the international system. For example, in the UK's recent trade agreement, it notes that it requires parties to align with carbon pricing standards. So I was wondering if you could maybe talk a little bit about how the policies we're seeing emerge in Australia around emissions, industrial policy, a potential CBAM might interact with the series of preferential trade agreements that Australia is party to.
What do you think, Jessica?
Yeah, sure. You never asked me that question before, so yeah, I'm happy to consider it. It's interesting because I think we're seeing with the CBAM, the carbon border adjustment mechanisms that are being proposed, and extremely important for me. I consider that to be an extremely important development in terms of trade, because I think it actually really it's very much a set of measures that are going to really impact on how countries can access one another's markets, but also they're going to be just so many complicated regulations around how the assessments are done and whether those are done in a way that is accurate and fair. So CBAM's really fascinating. The inclusion of requirements to meet certain standards in free trade agreements that's something that was actually pioneered, I think, by the US, where they were in their standard kind of template free trade agreements way back in the day. Well, way back in my career anyway. They were generating, effectively trying to impose their standards on their trading partner in a way that would make sure that they were not going to be disadvantaged. So that issues like labour standards and environmental standards would not become a race to the bottom, or it wouldn't be an advantage for others to have really bad labour standards or really bad environmental standards. And so that has been a common kind of idea, that you require like environmental labour standards. To require climate change mitigation standards thus isn't, I think it's probably not too much of a conceptual leap, but it's a really, I suppose for me, that's a very strict kind of application that I think will have a whole lot of, there'll be a whole layer underneath that of the iceberg of how to actually implement those. And interestingly, requiring kind of those kinds of standards of others, I think, is often used as a kind of like a ratchet, so that you can try to get enough of your trade partners willing to do it, and thus kind of create a norm in that sense that you then can kind of take on to a multilateral setting. It will be really, really difficult to do that with this kind of things, I think. But yeah, I think I have wondered a little bit about how those are going to be operationalized. And I think that will be the real nub there, is the implementation of it, how you will actually assess whether people are meeting it will be the really, really, really interesting part from a trade law perspective.
Yeah, so unfortunately running out of time, which is killing me because I have so much more to talk to about. So perhaps we will have another go, particularly when we see the rollout of this China challenge against the WTO, in the WTO against the Inflation Reduction Act, but also, I mean, the EU's investigation of Chinese subsidies for electric vehicles is another really interesting trade law investigation underway. But also, just after MC13, after the 30th Ministerial Council of the WTO, and again, failure to achieve material progress on improving the dispute settlement system in the WTO, and how that interfaces with all of these hard questions about the consistency of these climate change regulations with existing trade laws. Okay, Jessica, I think I'm just going to have to line you up again for another session, because there's still so much to talk about and to try and understand. And I'm sure all those DFAT trade lawyers are working frantically trying to get into the Department of Industry to make sure that this new Future Made in Australia Act complies with all of our WTO obligations. I'd love to hear how that's going for any of our WTO colleagues on this call or others. So that would be an interesting conversation too. Can I just say thank you? I don't know if there were any last words you wanted to say.
Thank you for having me. Yeah, happy to have another discussion at some future point, perhaps on any of the other issues that we didn't get to.
Thank you so much. This has been fascinating. Thank you to Moulis Legal for letting us have you for the hour, and hopefully they will let us have you again in future. Thank you to those online. This will be available on the ACITI YouTube channel. Yes, I can't believe it. We have a YouTube channel for others to watch who weren't able to join us live. We will continue to have these kinds of webinars. We have a live meeting in Sydney, happening in Sydney at the University of Wollongong campus on the 9th of May, with a panel looking at trade under Trump. So if you think things are complicated now, imagine a second Trump presidency, or at least come along and we'll all together try and imagine what life would be like under a potential second Trump presidency. Thank you again, Jessica. Look forward to seeing you at another ACITI event, and thank you for joining us online.